So this morning we're going to discuss the Clark case, the Bostock case, and the family leave article. And then we'll have a little bit of time left over. If anybody has any exam questions, you're welcome to ask them. I'll talk about that again for a second. I've already posted the study guide. I hope y'all have seen that. I think it's one page. And it's a little, the topics on it are general, but my hope in doing that is that you know that if something's not on there, then you don't have to worry about it for the exam. And that ought to cut out a lot of unnecessary preparation for you. There are no cases on the exam, so that also cuts out preparation time on reviewing that. It's strictly over the lectures and the lecture outlines. You can use your notes. You can use the lecture outlines that I've provided. You can use your own study sheet. You just can't use anything other than either what I've given you or what you've taken as notes. It is a take-home exam, so you can do it at your convenience. I've given you a pretty large window. I think it's going to be open from this Saturday, although I don't expect anybody to be hitting it on starting this Saturday. But it's there if you, point being, you can do it when it's convenient for you. This Saturday through the, is anybody looking at it? Is it the 7th, which is a Saturday? Yeah. So Saturday night, the 7th, would be the last time you could take it. So that gives you a couple weeks to do it. It's 50, I think it's 54 questions, each worth 2 points. So you could get a maximum of 108. So it gives you a little bit of chance for extra credit on it. It's true, false, and multiple choice. It is not intended to have any trick questions on it. It is intended to see if you guys have gotten the main points and the more important things that I've tried to stress throughout the semester. That's my intention anyway. So it shouldn't take you super long to do. I think if you review your notes, if you review the lecture outlines, particularly in the areas that the study guide says to go look at, I think you'll do fine. Shouldn't be anything new. Any questions about that? All right. Remember that do want your discussion questions done by tomorrow. So that I can go ahead and get you a grade in the book for those. So if you haven't done any discussion questions, finish those by tomorrow evening. Any questions on those? All right, so let's hit you will have a quiz this week. There's a quiz over the cases that we're talking about today and the family leave article. So everything that I'm asking you on the quiz, we're going to talk about in class this morning. We're going to answer those questions in class this morning. So if you pay attention, if you've read the cases, take good notes this morning, you should do good on that quiz. Quiz is due Monday night. That'll be the last graded item we have. And it will go live, I think, at noon today. I've already set it up to go live at noon. So everything should be set up for the rest of the semester. You should have everything you need. I know y'all will do well on it. Y'all done pretty good on all the quizzes. Okay, if there are no questions about the final or the quiz this week or the discussion questions or anything else having to do with required work or anything like that, then let's jump into the last cases we're going to talk about. First case I want to talk about is Clark versus Champion National Security. Who is the plaintiff in this case? Anybody? Clark. Thank you, Ward. Charles Clark is the plaintiff. Who's the defendant? All right, and what's their relationship? Who's who? Tell us who they are. Good. What does Clark do for Champion National Security? Who said it? Yeah, personnel management, human resources, that kind of thing. And is this a Is this case from a state court system or is it from the federal court system? Federal court system, that's right. And we know that because it's from the United States Court of Appeals for the Fifth Circuit. So you remember we divided our federal court system into circuits that are then divided down into individual states. And, well, I'm getting to that in a second. What law is at issue today? What law is the court worried or concerned about in this case? What law does Mr. Clark sue under? Workplace discrimination. That is the topic. Good. What specific law is he saying Champion violated? The Americans. Say it again. The Americans with Disabilities Act. Good. This is an ADA case. Clark says he was fired. Why? What's his claim? I was fired because. I'm sorry, Steve, say it again. He fell asleep at his desk. Well, that's not why he says he was fired. Why does he say he was fired? Because they were discriminating on his diabetes. Champion says they fired him. Why, Mr. Massey? For sleeping on the job, right. Champion says there's no discriminatory reason at all. He's sleeping on the job. Clark says not so much. You fired me. The reason you fired me is because I have a disability, which is diabetes, and also your conduct in handling my employment harassed me on the basis of my disability. So he's kind of got those two in there together. Is there any dispute that Clark is diabetic? No, there's no dispute over that. Champion doesn't claim that he's not. And in fact, Clark had asked for some accommodations on the job related to his mixing diabetes and disability. Related to his disability, I still can't say it. Related to his condition, what did he ask for? Y'all remember that? What did he ask for, Ms. Robinson? Good, a refrigerator to put his insulin in. They gave him that. Yeah, he said I'm gonna need you to be flexible with my hours because I may have to go to frequent doctor's appointments. Champion said that's very reasonable. Again, those are obvious or pretty concretely related to his disability. Insulin, yes. Doctor's appointments, yes. And could he still do the job with or without those accommodations? He could, but those accommodations certainly made it easier on him. And so those are not in dispute in this case because he asked for them and Champion granted them. He asked for a couple of other exceptions that Champion kind of pushed back on a little bit. What were those? Yeah, he wanted to not shave in violation of their policy. They fought him on that at first, and then they ended up giving in. His note didn't really tie the need to not shave to his disability or to diabetes, but Champion ended up giving in on that. And then the other one was the dress code. Yeah, he didn't want to tuck in his shirt, and he brought a doctor's note, Rianne. What did the doctor's note say? Or what did it not say? It never said that he couldn't tuck his shirt in. And so they kind of went back and forth over that. Champion's issue with those requests were that Clark didn't really document them in a way that tied them to his disability of being diabetic. If the doctor's note had said his diabetes prevents him from shaving every day, or it creates a dry skin condition that is aggravated by shaving every day, that might have been, Champion may have had to have accommodated that. If he had a doctor's note that says, I can't tuck in my, well, the tucking in the shirt was related to shoulder surgery, I think, wasn't it? He didn't even try to relate that to diabetes. All right, so Clark was asking for things. He was getting some accommodations. He wasn't getting some accommodations. But what else was going on during all this time? His coworkers were finding him doing what? Sleeping on the job. Good, Caleb. Sleeping on the job. The first time they tried to rat him out for it, that didn't quite work. Anybody catch why that didn't work? Yeah, somebody sent an anonymous picture of him sleeping, and Champion said, our policy is that we need to have more corroboration. It needs to be a little more concrete. Remember when I talked to you last week about how if you are in management or if you're the employer and you do things that are inconsistent with your policy, that can make you look bad in the lawsuit. And so Champion did the right thing, protecting their own liability by saying, let's wait till we get him. Let's wait till we really get him. So they did, and it happened, right? It happened again where he was sleeping at his desk one morning, and the manager went and got some witnesses, and they documented it correctly, and they sent it to management. And what happened to Clark, Mr. Clark? He got fired, right? He finally got fired. He was terminated. And that leads us to his lawsuit. He says, like we said a minute ago, I was fired because they were discriminating against me on the basis of my disability. Champion says, no, we fired him because he was sleeping on the job. So, how would, if you were Clark's lawyer, how do you tie his disability to getting fired for sleeping on the job being discriminatory? What's your argument for Clark there? Yeah, you're going to have to tie it now some way. Sadie? That is excellent. I like the way y'all are thinking now here at the end of the semester. Good job, right? At first blush, we look at his case and we don't really have much sympathy for that. But there are arguments that could be made. Yeah, I had low blood sugar. And what did Mr. Clark say? You guys didn't even come to find out if I was okay. Y'all just said, perfect, let him go. See, you work with somebody who has had that condition? Champion may have had a problem if, excuse me, may have had a problem if it turns out that Clark went to the hospital in a diabetic coma or something like that. If it really had been his diabetes. He wasn't kind of after the fact able to tie it in enough. But if we take off our lawyer hat for Mr. Clark and put on our lawyer hat for the employer, even assuming that the sleeping was diabetes related, let's give him the benefit of the doubt. What is Clark Champion's best argument? What's our argument for them as their lawyer? That's exactly right. I don't have to give you an accommodation if you still can't perform the essential functions of the job with or without the accommodation. So remember I told you the other day, the with or without always confuses me. So the accommodation that Clark would have been ostensibly asking for would have been the ability to sleep on the job. Could he do the essential functions of his job with that accommodation? Can he do the essential functions of his job while he's asleep? No. Without the accommodation, he can't do it while he's asleep. Same analysis. It's a basic requirement of the job to be awake and alert. And so therefore, that wasn't something that the ADA would require Champion to accommodate. You don't have to give an accommodation if the person can't do the job with or without the accommodation. They've still got to be able to do it. He could still do the job without a refrigerator in his office. He would have had to have packed a cooler or made other arrangements. But he can't do the essential functions of the job while he's not awake. And that essentially carried the day. The court, in their opinion, takes you through their analysis of the evidence that Clark presented. And the court tells you, like we went over last week, that in discrimination cases, you might have a smoking gun piece of evidence that directly shows discrimination. If you've got that, you don't have to worry about this burden shifting stuff. But if you don't have direct evidence, you can say, I think it was because it was because of my disability. Then the employer has to articulate a legitimate, non-discriminatory reason. And then the employee has to turn around and show that that was bull. Y'all remember how that worked? So Clark first thought that he had direct evidence of discrimination. And the court talks about other cases, precedent, prior cases that are binding, and compares Clark's examples of direct evidence to prior cases. So they say in the Portis case, a demoted bank employee alleged sex discrimination, and the evidence she had was that her supervisor told her she wouldn't be worth as much as the men would be to the bank, and she would be paid less because she's a woman. We don't need to do any burden shifting to let the employer give a non-discriminatory reason and then turn around and have to show that that was pretext. That's direct evidence right there. The court went through the ETN case where that was a casino. The employer basically said, we're not going to hire black people. That we don't need any inference on. That doesn't require any leap in logic, or doesn't require any indirect conclusions to be drawn. That's direct evidence of discrimination. The Jones case, same thing. The employers basically said, we're not hiring this person because of their race. The court also gives the case of the Rodriguez case, where the employer admitted that the guy didn't get the job because of his diabetes. Again, direct evidence of discrimination. The court then says, we look at those examples, then we look at this example, and all Clark really has that he's saying is direct evidence is this email that says, perfect, let him go. The court says, that would require some inference. That would require some indirect conclusion, drawing some indirect conclusions. Because it doesn't mention on its face or directly discrimination or the diabetes. So the court is saying without direct evidence, then Clark still could use the burden shifting. He still could say, well, I don't have direct evidence, but I still think it was because of my disability. And so then the burden shifts to Champion to give a non-discriminatory reason, which they said was sleeping on the job. And then under a burden shifting framework, it would be up to Clark to then show that it wasn't because of sleeping on the job, it was because of the disability. And that's when the court gets more into what we have already talked about, which is that he can't show that he could do the job with or without an accommodation because he's got to be awake. The court then talks about his second claim. Remember, he had, I was fired because of my disability, but he also said I was harassed on the basis of my disability. So the court's got to look at that claim under a different framework. So the court says, when we talk about harassment, we're looking to see if the harassment was sufficiently pervasive or severe enough to alter the conditions of employment and create an abusive working environment. Okay? That's a sliding scale. An employer could say something one time and it could be so bad and so offensive and so harmful that it's harassment. The employer also could do things a drop at a time, maybe a comment here, a comment there, that in and of themselves, if it happened one time, wouldn't really rise to the level of being severe or pervasive. But cumulatively over time, if the employer is whistling every time the employer walks by, that happens one day, maybe not severe and pervasive. It happens every day for 3 years. It's easier to see how that's harassment. So the court says we're going to look at the frequency of the conduct, its severity, whether it's physically threatening or humiliating, and whether it unreasonably interferes with an employee's work performance. So let's look at Clark's harassment claims under the lens of those factors. What really was he saying? What's his best argument that he was harassed? I'm not saying it's a good argument, but what's his best argument? Miracle says you didn't like any of them, huh? You're a champion all the way. On the harassment, probably. I mean, his best argument is they were always giving me a hard time about my appearance, my condition. I say that loosely. They were always pushing back on me for things that I needed to do. I brought doctor's notes. They just were always being difficult. I'm having a hard time making the argument for him. Champions is much easier to make. We gave him 2 accommodations. We gave him a 3rd accommodation on shaving when really he didn't ever prove that was related to his disability. The only thing we denied him was his the dress code thing. That was related to shoulder surgery. Everything that we addressed with him had a basis and a root in company policy, written company policy. That, by the way, who was in charge of training employees on company policy? Mr. Clark was. That's part of his job. This is not something that he wouldn't have known about. So under those circumstances, the court just said, number one, it's not severe and pervasive enough. Number 2, it's just really not even tied to his disability. So both of his claims failed. Any questions on the Clark case? That was a 2020 case, I think. Yeah, 2020. So if this opinion was issued by the United States Court of Appeals for the 5th Circuit, they ruled against Clark. Would Clark have had any other appeals that he could have made? Could he have appealed? Are there any appellate court levels above the Court of Appeals? Yeah, the U.S. Supreme Court. In the federal system, the U.S. Supreme Court is above the Court of Appeals. All right. Flip to Bostock versus Clayton County. Who is the plaintiff and the defendant in this case? Who brought the lawsuit? Mr. Bostock, not Mr. Clayton County. Mr. Bostock. The defendant is Clayton County. This is a Georgia case. So Mr. Bostock was an employee of the Clayton County, I think, Department of Family and Children Services. I'm not sure if it says that in your case, but I know that is true. So he was a state worker, and he claimed that he was fired for what reason?
Sexual orientation.
Good, Mr. Wilmot. He said I was fired because I was gay. He's an employee of the state of Georgia. This case is in the U.S. Supreme Court. How did we get in the federal court system? Well, what is it about this case that makes it eligible for Mr. Bostock to have sued Clayton County in the federal court system? Federal law. Boom. Very good. And what federal law is at issue in the Bostock case? Title VII. Title VII. I think I spoke over you. I apologize. Title VII is the Civil Rights Act of 1964. You remember we talked about this statute that, oh, by the way, well, I'm old. Y'all aren't old. Does anybody watch Jeopardy? Did y'all watch last night? Oh, that hurts. No, that cut deep. All right, the clue was a 7-letter word for a law passed by a legislature. Come on. Statute. Thank you. Very good. You have to say it in the form of a question. What is a statute? Good, Mr. Cochran. You win Jeopardy. You win business law Jeopardy. All right, so I got off track a little bit. If you notice in the background of this case, the Supreme Court is actually hearing more than one case. It's not just Mr. Bostock's case. It's 2 other cases that were making their way up through the federal court system from separate circuits. And they had different outcomes, completely opposite outcomes. So one of the reasons that the Supreme Court will take cases is to clear up inconsistencies between decisions from lower circuits that are inconsistent. So we had the Bostock case come up through the 11th Circuit, and it found in Bostock's favor. But out west, well, let me see. No, it's, 2nd Circuit, I believe, is the Western Circuit. In one of the other cases, they found that Title VII doesn't cover sexual orientation. So we've got 2 federal courts, both issuing binding precedent to courts in their circuits that are in direct conflict. So the U.S. Supreme Court said that's the type of case that we need to take so that we can clear it up and we won't have inconsistent interpretations of federal laws. So the question before the Supreme Court in Bostock is whether an employer can fire someone simply for being homosexual or transgender under Title VII. Remember, Title VII, if we're reviewing, says that an employer may not discriminate on the basis of race, color, national origin, sex, and religion. There are other protected classes, they're just in different laws. This particular statute covers those protected classes. So if we're boiling it down, y'all, this is very important.
These are all for you.
Thank you so
The
much.
cupcakes might be a little dry, but you can.
Oh, there's no
do
such
as
thing
much
as a dry
please.
cupcake. Thank you, Amanda. Amanda and her mom make cookies for all the holidays, and so this is my Christmas delivery.
No, that's not.
Oh, is this Thanksgiving?
No, that's Louie and Bingo. We had a 6th birthday party. That was what was left
Oh, hell yeah.
over.
All right, thank you. They're delicious. So now I still get Christmas.
Yeah.
Okay, all right.
Are you gonna pay this time?
Yep. Paid you last year. Pay you more this year.
600?
Good deal. Same order. Thank you. All right. So where were we? The question was whether or not Title VII says you can or can't fire somebody for being gay. So we're taking Title VII, again, doesn't mention anything about homosexual or transgender. It just says you can't discriminate on the basis of sex. So the court is having to decide, does that word in the statute include homosexual and transgender? Now, if you noticed, this was a split decision, so it wasn't unanimous from the Supreme Court. We had a majority opinion and a couple of dissenting opinions. Everybody agreed that it should be illegal to discriminate on the basis of sexual orientation. Even the justices who dissented agreed that. But the main point of contention between the majority and the dissent was what? Who caught that? What was the main disagreement they had? Not really whether Title VII should prevent discrimination on the basis of sexual orientation. It was what, Ms. Marshall? Right. The question that the justices disagree on is whether or not this particular law, as it's written, prevents discrimination on the basis of sexual orientation. One group of justices, the majority, said it does. The dissenting opinion says it ought to, but that isn't what it says. And oh, by the way, whose job is it to amend or change a law? Not ours, but it'd be up to Congress. That's the beef, really, between the justices here. Not that it should or shouldn't, but whether it does as written. So you see some sort of jurisprudence philosophy coming in here where some of the judges say you should only take the plain meaning of the words in the statute, the meaning as they were understood at the time it was written. We should not update statutes through the court system. Statutes should be updated, but in our system of government, that's done by our elected representatives, senators. That's how laws get changed, not by courts. I always find that to be interesting because this is a frequent disagreement that you will see in appellate courts. And the majority, well, the group of justices that is interpreting the law as changing or updating it always figures out a way to say, well, that is what it really says. And then the ones who disagree say, you're just making new law. It'd be a lot more genuine if you would just say what you're doing instead of trying to pretend like you're not changing the law, that you're reading into it the plain meaning. Just say what you're doing. But I would submit to you, I'm not a scholar on the Supreme Court, but I would bet that some of these justices that are saying in the dissent, you're making new law, I bet you can find opinions where they do the same thing and the justices on the other side accuse them of making law. I don't think you have judges or Supreme Court justices who always land in one camp or the other. Neither here nor there, really. But that's their beef. So the majority says, we think that if we go back and look at the plain meaning of the word sex, that does include discrimination on the basis of sexual orientation. How does Justice Gorsuch, who wrote the majority opinion, how does he get there? How does he tie the plain meaning of the statute to covering Mr. Bostock's case? He says that the word sex means male or female. And if we change the employee's sex, just their maleness or femaleness, and that would change the result of the employer's decision, then we have discrimination based on the plain meaning of the word sex. That's how he tries to do it. So he says, here's his example. I have two employees. They're both attracted to men. One's a man, one's a woman. The man gets fired. What is the only difference between the man and the woman? Their sex. That's how Justice Gorsuch says, I'm looking at the plain meaning of the word in the statute, and plain meaning of the word means male or female, and if I change male or female, it changes the outcome of this employment decision. That's pretty much discrimination on the basis of sex. The dissent says, yeah, but whenever we talk about plain meaning of words, we go back to the plain meaning of the words and the understanding of the public and the lawmakers at the time they made the law. And if you're telling us that in 1964, when the authors of this law wrote, we prohibit discrimination on the basis of sex, that they thought that it was commonly understood at that time that that would cover homosexual and transgender persons, I just don't buy that. That's what the dissenting justices are saying. There's no way that in 1964 that was what everybody understood this law to mean. So therefore, if it's going to change, it needs to be changed by the legislature. But it wasn't. It was changed by the Supreme Court. This is a relatively, isn't this a 2020 case also? Yeah. This is 4 years ago. So after this opinion came down, future discrimination cases under Title VII could be brought on the basis of sexual orientation or transgender status. The Supreme Court's interpretation of the law did change the law. And the courts do that, despite the fact that they do it when it's convenient for the way they want the case to come out. And then when it's not convenient for the way they want the case to come out, they say that's Congress's job. So that is how that case went down. Any questions on Bostock? All right, let's talk about paid leave for a second. So refreshing your memory, in this country, we have the Family and Medical Leave Act. We've talked about this law, and it provides that an employee who's been with its employer for 12 months can have 12 weeks of unpaid leave for a pretty wide range of things. The criticism of our law is not so much of what all the things you get leave for. In fact, your article says our definition of things that qualify for leave is pretty broad compared to other countries. The main difference is that ours is unpaid, meaning the employer is not required to give paid leave. An employer could give paid leave if they want to, and a lot of employers do. But they're not required to. They are required to give you 12 weeks off if you qualify and to restore you to your same or similar position when you get back. So the article asked you to think about the American policy versus the way the rest of the world does it. So your article tells you we're one of 6 countries with no national paid leave, meaning we don't have employers are not required by law to pay workers on leave. 186 countries offer paid leave for new mothers. Only one of them is under 4 weeks. Again, we're 12 weeks of unpaid. So we have 0 weeks of paid leave. 174 countries that offer paid leave for personal health issues. And almost all of them pay for 4 weeks or more. Again, we're 12 weeks guaranteed, but none guaranteed paid. So with that backdrop, what is your opinion, assessment, observation about the way we do it versus the rest of the world?
However, 25% of laborers in the U.S.
25% of them get paid, meaning that we have some employers who have just chosen to give paid leave. But what about the idea that it's not mandatory? I told y'all last week when we talked about this, as a small business owner with one employee, that'd be pretty rough on me. If that law applied to me, my assistant could take 12 weeks off every single year and get paid for it if she could come up with a valid reason, qualifying reason. If you're the employee, would you like to have 12 weeks of paid leave every year? Hell yeah. What about my assistant? If you're an employee, you would love paid leave. If your manager takes 12 weeks off? Are you above them or below them? I mean, they can, but you're saying you might have to step in and do some of their job? Somebody would have to cover. What's the military policy? It's paid. All right, so if you qualify, you're going to get paid for your leave. And that would include maternity leave. That's one of the qualifying events. Good policy. So the difference in you, the military is 100% paid leave. So you're right. Some of these laws, some of the countries that do mandate paid leave, it might not be 100% of your salary. It might be a percentage of it. That might be a way to make it easier on smaller employers. But the difference is Ms. Marshall serves in the military. She gets 12 weeks of paid leave. My assistant breaks her leg or has to care for a dying parent. She can take 12 weeks off, but she's not, I shouldn't say it that way. I'm not required by law to pay her. So first question is, well, what do y'all think about, I know what I think about this. Big company, thousands of employees, deep pockets. Every employee, if they're guaranteed paid leave by the government, what percentage of the workforce do you think is going to find a reason to take 12 weeks of paid leave every year? More and more every year. A pretty high, I mean, so did that happen in the military? Did you see people taking advantage of that? So the way that it was administered made abuse. Gotcha. So the Army was strict about it. So Mr. Clark wouldn't have done well in the military, right? He's a person though that I feel like would have tried to take 12 weeks of leave every year. There are people like that who are going to do that. Work. Did I cut you off?
No.
Okay.
I was saying I like that. That sounds.
That they do that?
Yeah.
Yeah. As long as people aren't going to abuse it, but knowing human nature, they're going to try, right? People are going. I mean, they're going to push it. I mean, that's the way it's going to go. Did you have something to say, Miracle?
Yeah, my auntie worked for corporate Home Depot, and my grandma got sick around like this time of the year, and she had to take 12 weeks and some, so they gave her the 12 weeks, but then they let her take the other couple weeks off. Cause my grandma passed away after that, and they just didn't pay her.
So they gave her 12 weeks of paid leave,
Yeah.
and then after that they let her stay on leave. They just didn't pay it after
Yeah.
that. And she got her job back. She got to go back to her job.
It was complicated after that, but yeah.
All right, so first question is that I'm going to poll the class. Should we have mandatory paid leave or not? Should the government require it? Should they require employers to pay? And it would probably be something like, I imagine it would be something like, 50 or more employers or 25 or more. I don't think it would apply to people like me. Just like Title VII and a lot of the federal discrimination statutes don't apply to a small business or a sole proprietorship. So I think it'll be something like that. But with that kind of parameters in place, let's start down here with Mr. Cochran. What is your vote, Senator Cochran?
Whether they should require it?
Mm-hmm. Whether it should be a federal, any kind of, let's just say any kind of paid leave. I'm sorry. Let's just say, don't worry about how many weeks. We're going to come back to that next. So,
I don't think it should be.
all right. So the way we do it now, basically. All right. Senator LaFavor?
I think it should be split. So based on how long you've been at the company, you get paid for 12 years. Not get paid.
So your idea would be a graduated schedule. The longer you've been there, the more paid leave you get. Let's do this so we don't have to go around twice. And we'll go back to Caleb. If we did have mandatory paid leave, where would you set the number of weeks? And I put you on the spot because you didn't have time to think about it.
I mean, if you're going to have mandatory paid leave, I think it should vary based off what you're taking leave for. I mean, something like bereavement, maybe
Okay.
you need a full 12 weeks. But
Gotcha.
serious medical procedure and a recovery period after that.
So you would look, it'd be less blanket and more maybe specific and graduated and that kind of thing. That's fair. How many weeks, Miracle?
I would.
You like what he said? All right. Senator Cochran's idea is gaining some support here in our class Senate. What do you say, Senator? Yes, we should have some mandatory paid leave. All right, how many weeks? What's the minimum?
I agree with what they said. Like the doctor suggests,
What if it's more than 12 weeks? Okay. All right, so you're anywhere between 1 and 12 weeks and depending on condition. Yes, sir.
But is that not, honestly, like if you were to require paid leave, but you cap it at 12 weeks, you're not kind of discriminating against people that have more serious health?
What do y'all think about that?
When you look at your bills, look at not having income after those 12 weeks, and you're still injured, you had a trauma, you got injured, whatever, in a car accident, and you were still being a doctor, you're still doing everything that you need to do, and it's past that time frame, you said 12 weeks is enough if it was major.
But we already have social insurance programs in place for people like that. We
Well,
don't really
John,
think.
you have disability.
Yeah. And there's Aflac.
They have, yeah, actually work there too. But they have short-term disability, they have, long-term disability, workers' comp and all that. It is necessary to have all that, and just, I mean, it does depend on how long you, what your, condition is.
Yeah, and you're saying, are we discriminating against people? Yeah, we would be because we're going to put the cutoff somewhere, and we're necessarily going to be discriminating against people who need longer.
But that should be a decision.
It would be unpaid after.
Well,
doctor to say how long somebody medically
yeah, it should be. So Caleb's point is, it should be for the doctor to decide how long somebody can't work. What about permanent disability? We have that in this
we have
country.
a social-
Yeah, and that's a socially. Um, those are good points.
And then if you get more, like a doctor, add on to that. So let's say flat rate, like guarantee, okay, 12 weeks. And then after that point, let's say doctor, okay, we can work. Then the
As long as you exempt small businesses, I'm on board. See,
just that when I said.
thank you.
But I think if we can all agree with and these are good businesses, you don't want insurance making any more money off of it. You can kind of create anything like, pay leave membership co-op for businesses and pay into it. So,
And that's what we do with unemployment and workers' comp. And some countries do exactly what you're saying, Mr. Massey. They some of the paid leave is actually subsidized by the government from a fund that everybody pays into. So much like we do unemployment. So France is 12 weeks paid leave for maternity leave, sickness, caring for family members, all those kind of things. And the government subsidizes does the employer also have to pay some, or is it all government? Who regulates it? The government does? That you mean, is it up to the employer or the government? Yeah, employer. So what gotcha. So we're bringing insurance back into it. What do they do in Germany? 10 weeks paid? All right. So you don't love your citizens as much as the French? Just kidding. It's an interesting question, but we have not. And really, the article that I assigned you was from 2021, I think, which would have been right after Biden got elected, and they were proposing to add mandatory paid leave into some legislation that didn't pass. And you don't hear about it much anymore, and you really didn't hear about it much before then. So it's just not a very hot topic politically here. If we wanted to have mandatory paid leave, I mean, Congress could pass that law. Some states have mandatory paid leave. So it could depend on what state you're in. You might have the right to that. It's just not a national requirement. Yeah, and a lot of them do, like the Army. Well, that's a good question. That's kind of the question I put to you. Should it be mandatory, or should we leave it up to employers?
Another company could just go offer 12 weeks of paid leave in the same industry.
Oh, let the market take care of it, huh? You can gain a competitive advantage by offering that. Yeah, and if we know how that works, people are followers. I mean, if that's what you got to do to match what the other people are doing, you'll do it in a completely free market system. So what you're talking about is, free market versus government mandating it. And
if you require paid leave as a law, then people are going to stop getting hired that have a higher risk of needing paid leave.
That might increase discrimination in employment. That's very real. That's very real. I mean, let's be honest. I'm not talking about whether it's right or not, but in the back of a hiring manager's mind, are they thinking, if we have mandatory paid leave, are they going to be thinking, how likely is this person to go out on leave? She's 28. She got married last year. Or she's in a wheelchair. I don't know. I'm going to make assumptions about her physical health based on things I'm seeing. I mean, I wonder if the research would show in countries where I'm sure this has been studied, countries that have mandatory paid leave, if these problems have shown up that way. You think so?
I had to choose between hiring a person who had a disability, had amputated leg, who had a leg, and choosing a person who didn't, who was fine. The case could be made that we discriminated against her, and she had more knowledge of how to do the job than the other person.
So who'd y'all pick, the amputee or the other one?
But if we basically didn't hire her, she'd have a case against us. So
Did that factor into your thinking that you didn't want to be
that
seen as discriminatory?
basically we had to decide upon, if we have all the accommodations for her if she did the job, and would she be able to get around and do the same
Which
job?
is the reverse of what you're talking about. Now we've got decisions that might be made because we're fearing. That's reverse discriminate. Right. That's exactly right. Yeah, I could swing. That's what I mean. That's the other side of what you're talking about.
But because she knew more, she was hired.
She ended up being more qualified. Was that in the back of your minds, though? And that's why my client that I advise on employment stuff, that's why they talk all the time. They're like, how does this, we think through how this looks. I mean, what are all the things we need to be thinking about here? Even though we're not basing a decision based on any of these things, we've got to be cognizant of how it looks.
So, with all of this going on in y'all's argument, how is it right now as someone who you said went through it? Pretty bad or good, or what would you say?
It doesn't have to be, you have to have a legitimate reason, and it has to be verified by a doctor.
So you like this system?
Because I have to deal with it every day. So I've had to put two people out, but at different times, it was only for the amount of time needed to recover from their illness or taking care of them. And even my mom will be going out for that I have because he has to have treatment.
And you're saying leave it?
It's fine. It is.
There's a lot of factors at play, right? I mean, like we might agree on, we might be like the justices in Bostock. We might agree that that employers ought to offer paid leave, but we might disagree about whether or not the government should make them do it. Right? We have that debate all the time about the limits of what the government ought to mandate employers do. What you should do, whether or not what you should do versus somebody making you do. We're not getting into that today, but that's a great question, Warwick, and illustrates one of the big political questions I think that's popular today. Was how far government ought to go, is how far government ought to go. I didn't leave much time for questions on exam review. If you want to stick around, if you have one after class, do that. If you have a particular question about something that's confusing you, just shoot me a text. We can Zoom, we can talk on the phone, we can do whatever. I'm available to you for any kind of exam questions that you have. that's all that I have. I really appreciate this class. I'm going to miss you guys. Y'all have been great. So everybody have a good Thanksgiving and Christmas holidays. And if y'all need anything in the future, let me know.
Oh, we were having a discussion about, we see you with the cup every day. My guess, Diet Dr. Pepper.
Oh, okay.
I was thinking Coke at first, but
Nope.
you're too,
You're both wrong.
you're too in shape.
It's not Diet Dr. Pepper and it's not Diet Coke. Not just Coke.
Coke Zero.
No, it's not like bourbon and Coke. Now, hold on. No, it's Coke Zero. It's Coke Zero.
Hey, Coke Zero, it's every day, Coke Zero. You just, that's your go-to drink.
I have to have something really cold in the morning, and I don't like coffee. You got to have caffeine. I take my caffeine cold.
So you need a lot of Coke Zero.
Yeah, I do. Oh, hey, Darren, if y'all want a cookie or a cupcake, come down and get one. These are really good. I'm not going to eat them all. That's a good question. I should put that on the exam. Y'all help yourselves.